So, what happens when a contract, a deal you were counting on, just falls apart? It's not always about getting your money back. Sometimes you just want the thing you were promised in the first place. That's exactly where the concept of specific performance steps in. In this explainer, we're going to dive deep into India's Specific Relief Act to figure out exactly when a court can step in and force someone to keep their end of the bargain. Here's the roadmap for our journey. We'll start with what is now the mandatory rule of performance, a huge change in the law. Then we'll look at the first line of defense, questioning the contract itself. After that, we'll explore which types of contracts a court just won't enforce, period. Then we'll get into a critical part, how the person suing has to prove their own conduct was fair. And finally, we'll see what tools the court has to deliver a complete and final remedy. All right, let's get right into it with the biggest development in this area of law. We're talking about a foundational shift that happened just a few years back, and it completely changed the game for specific performance in India. You see, before 2018, getting a court to actually enforce a contract was, kind of up in the air. Judges had the discretion to say, no, just give them some money damages instead. But a major amendment in 2018 completely flipped that. Now, enforcing the contract is the rule, not the exception. The court's starting position is that a promise is a promise and it must be kept. And this isn't just a suggestion. It's written right into the law. The amended Section 10 of the Act states, and I quote, "The specific performance of a contract shall be enforced by the court, subject to the provisions contained in subsection 2 of Section 11, Section 14, and Section 16. That little word, shall, is everything. It removes the maybe and makes it a mandate. Of course, as it notes, there are some important exceptions we'll cover, but the default is now clear: you shall perform. This entire shift is really built on an ancient, powerful legal principle, pacta sunt servanda. It's a Latin phrase, but what it means is incredibly simple. Agreements must be kept. This idea is the philosophical heart of the 2018 amendment. It's the law saying that the promises we make to each other matter, and they should be honored. Okay, so just because performance is now the rule doesn't mean it's a sure thing. Not at all. The very first hurdle, and the most common defense you'll see, is an attack on the contract itself. The question becomes, was this even a valid, enforceable agreement to begin with? This is where Section 9 of the Specific Relief Act comes into play. Think of it as a bridge that connects us directly back to the bedrock of contract law, the Indian Contract Act of 1872. What Section 9 says is, look, before we even start talking about enforcing a contract, you have to prove that a legally valid contract actually exists. This means all the standard defenses from contract law, things like fraud, coercion. And the logic here is grounded in another core legal idea, captured by the Latin maxim ex dolo malo non oritur actio. That's a mouthful, but it translates to a pretty straightforward concept. A court will not help someone who bases their claim on an immoral or illegal act. Basically, the courts aren't going to get involved to help you enforce a shady deal. So what kind of arguments can a defendant make here? Well, they could prove there was never actually a final, concluded contract. Or maybe one of the parties wasn't legally able to make a contract in the first place. Say they were a minor. They can also show that their consent was tainted by fraud, threats, or lies. And, of course, if the whole point of the contract was illegal, the court will absolutely refuse to enforce it. Any of these can stop a claim right in its tracks. Now, let's imagine we have a perfectly valid contract. Everything seems to be in order. Are there still cases where a court will say, "Sorry, we can't help you"? Yes, absolutely. The law itself recognizes that some agreements are just not built for forced performance. And for this, we turn to Section 14 of the Act. This section is incredibly important because it lists 4 specific categories of contracts that a court simply cannot enforce through a decree of specific performance. These are absolute bars, no matter how valid the contract might otherwise be. Let's break these down. First, if you've already gone out and hired someone else to do the job, that's called substituted performance. You can't then turn around and ask the court to force the original person to do it. Makes sense, right? Second, courts will not get tangled up in contracts that need constant, ongoing supervision, like overseeing a 5-year construction project. Third, contracts that depend on personal skill or qualifications. You can't legally force a musician to perform or an artist to paint. And finally, if the contract can be terminated by its very nature, a court won't force the parties to stay in it. The reasoning behind all of these rules is really just common sense, and it's captured by another Latin maxim, lex non cogit et impossibilia. It just means the law does not compel the impossible. It would be impossible for a court to supervise a project for years, and forcing someone to perform a personal service feels a lot like forced labor. So the law is powerful, but it's also practical. So let's say the contract is valid, and it's the kind of contract a court can enforce. We're still not done. There is one more giant hurdle, and this one has nothing to do with the contract or the defendant. It's all about the plaintiff, the person who is actually filing the lawsuit. Their own behavior gets put under a microscope. The guiding light here is one of the oldest principles of fairness in law. He who seeks equity must do equity. Put simply, if you're coming to the court asking for a fair outcome, you better be prepared to show that you've acted fairly yourself. You need to have, as they say, clean hands. And this principle is the absolute foundation of Section 16 of the Act. This principle breaks down into a crucial two-part test for the plaintiff. They must prove both readiness and willingness. Now, these two words sound pretty similar, but in the eyes of the law, they are very different. Readiness is all about your financial capacity. Did you have the money to do your part of the deal? Willingness, on the other hand, is about your conduct. Did you consistently act like someone who wanted to see the contract through? You must prove both. And we don't have to guess at these definitions. The Supreme Court laid it all out very clearly in the landmark case of J.P. Builders versus A. Ramadas Rao. The court held that, I quote, readiness refers to financial capacity and willingness refers to the conduct of the person. And the key takeaway is that a plaintiff can't just show up and say they were ready and willing. They have to prove it with actual substantive evidence, things like bank records to show readiness and emails or letters to show willingness. Okay, we've made it. Let's say our plaintiff has cleared every single one of these hurdles. The contract is valid, it's enforceable, and the plaintiff has proven their own clean hands. So, what does victory actually look like? The law gives the court a whole toolkit of remedies to make sure complete justice is served. The main prize, of course, is specific performance itself, where the court issues an order compelling the other party to do exactly what they promised. But the law has evolved to offer a very practical, modern alternative, substituted performance. This is basically a statutory right to self-help. It allows the injured party to say, you know what? Fine. If you won't do it, I'm going to hire someone else to get it done, and then I'm coming after you to recover the costs. It's often a much quicker path to a real-world solution. But the court's power doesn't stop there. Section 22 is designed to let the court tie up all the loose ends. So, in addition to ordering performance, the court can also order the handover of property, it can deal with partitioning that property, and it can order the refund of any deposit or earnest money that was paid. The whole idea is to provide complete relief in one single lawsuit, so people don't have to keep coming back to court for the same underlying issue. This all brings us to a final big picture question. By making performance the mandatory rule, has Indian law made a trade-off? Have we gained procedural certainty, but in the process lost the flexibility and fairness that comes with judicial discretion? Have we sacrificed equity for the sake of a clear-cut rule? That's a really interesting debate that legal scholars are still grappling with today, and the answer could shape the future of contracts for years to come.